For all my trial advocates out there, you're gonna wanna watch this video because we're gonna go over 5 tips for courtroom success. So whether or not you have a trial or maybe a hearing, you're gonna wanna watch this video because these tips you'll be able to implement anytime, every time you go to the courtroom. Stay tuned. Welcome to Law Venture. My name is Jarrett Stone. For those that are not members yet of this channel, be sure to hit that subscribe button below. By the way, as always, there are freebies below in the description. Be sure to check those out. Those are simple to get. All you have to do is click the link, type in your email address, click send, and then boom, go look in your inbox. Okay, enough of that. Let's go ahead and dive in to tip number 1 so you can start having courtroom success today. Tip number 1 is to outline your argument every single time. Even if you have a 15-minute hearing, you need to write an outline of any anticipated arguments you may end up making. And you also need to practice delivering that particular argument, that particular outline. Now, you may have an Allen Iverson approach when it comes to practicing. If you don't know what that means, here's a quick clip.
I'm not shoving it aside, like it don't mean anything. I know it's important. I do. I honestly do. But we talking about practice, man. What are we talking about? Practice?
Look, you do not want to take the Allen Iverson approach when it comes to not practicing. You really do need to practice your legal arguments, without a doubt. And I can tell you, and I'll ruin some of the magic, that all the good lawyers I've ever met, they all practice. The ones that say they don't, they're either lying or they've basically made the argument 1,000 times in the past, and so they have it down pat. In particular, you need to make sure that you practice because even if you were to deliver a B+ argument your first time in the courtroom, that means that you're making your client the guinea pig to your argument. And if it's a B+, don't you think the client deserves to get the A+ version of you, the A+ version of the argument? Because if things go wrong, if the jury rules against you, if the judge rules against you, do you really want to just have that weight on your shoulders of like, yeah, it could have been better, I should have practiced? Now, this also takes me to the importance of having an outline, because what you want to do is have basically a loose, structured outline and not a script. If you need to work on a script initially and transition that or translate that to an outline, that's going to be so important for so many reasons, and here's why. One of the biggest benefits to having an outline is it allows you the flexibility to get off the outline. Let's say you're working your way down argument A and you're about to talk about argument B, but the judge during the hearing or maybe during trial, if you're trying to get some type of evidentiary issue resolved, the judge, instead of asking you about argument B, decides to skip down and go to argument C. Now, if you were stuck to a script and all you knew was that script, it's gonna be a little awkward and it's gonna be a little bit harder if you have to make that jump. But if you have an outline, and if you're comfortable with that outline, you can plug and play however you want to do it. And so you can transition from argument A down to argument C, and then incorporate argument B right underneath that. And to the judge or to whoever's listening, they don't know that it just went from ABC to ACB. Instead, it still seems like ABC to them, and it makes it a much smoother delivery overall. And at the same time, if you have this outline and for some reason you get off topic just because something comes up, right? A fact comes out or opposing counsel makes an argument, then you can plug and play those facts, those arguments into your outline and you can use it accordingly. And that allows you to adapt your outline to the events that are unfolding in front of you. The most awkward thing is whenever somebody is trying to stick to a script or they're trying to come up with an argument that they've been thinking about in their head, and they're not adapting to what the witness just said, to what opposing counsel just argued. They're not taking those facts head on because they're just married to a script. So stay like water, my friends, use an outline. So after you have your outline and you practice repeatedly over and over again to where this argument becomes second nature to you, but you also have the flexibility to adapt to the courtroom, that's gonna make you dangerous in the courtroom. Because what ends up happening on game day is that you're making this argument and your mind is having to think about 100 different things. You're making this argument and you're having to think, okay, where do I walk? Where do I go? Where do I emphasize where I need to emphasize? When do I need to pull out these documents? When do I need to point at this or point at that? What is the judge thinking right now? And then you start trying to read the judge's face. Is he paying attention? Do you need to have a dramatic pause to get the judge's attention? Same for the jury. Do you need to move over here and get closer to a particular jury member because maybe that jury member you can tell is starting to fade a little bit and you need to capture that person's attention? You have all of this going through your mind, and you also have the built-in anxiety that comes with public speaking. And so you may be looking at the judge and thinking, okay, I need to get his attention. But at the same time, is he not listening to me because it's a bad argument? And you just kind of have these thoughts and this energy that's just racing through your mind. And the biggest benefit of practicing and having this outline is if that can take the least amount of mental and brain power possible because you have it down pat, you know it cold, then you can analyze these situations. And if you were to just have kind of that freak out moment at some point in time to where your mind goes blank, well, guess what? You just go back to your outline and you continue on and nobody knows. Let's say you get off topic, judge asks a question, judge asks a following question. At some point in time, you also hear the opposing counsel stand up, make an objection. So you have to answer that objection and you still haven't been able to get back to your outline and your argument basically has been on pause for 5 minutes, 6 minutes, 7 minutes. And it's like, okay, where was I? Well, all you have to do is just go back to your outline and then go ahead and continue on that point and just keep moving forward. And you don't really have to worry about, okay, this is what I need to say, this is where I need to move. No, instead, with that practice and the outline, you'll be set. Okay, there was a little bit of overkill on that one, but I can't stress this tip enough. It's all about preparation. It's all about being like water. Let's move on to the next tip. Now, tip number 2, I'll be honest, it's not the sexiest tip. It's not gonna be some type of game changer. In fact, you may be kind of turned off by this entire idea. You need to use PowerPoints in your arguments. I know. In fact, this is a little bit of a hypocritical statement, argument, recommendation, whatever you want to call it from me, because whenever I was recently licensed, I went through a phase where I'm like, I don't need PowerPoint. My arguments are so compelling, they're so interesting that people don't need to have the visuals. The words I say are gonna paint a picture perfect scene. Everyone's gonna be on the same exact page. But then the more I started using PowerPoint and the more I started using the visuals, I started seeing better and better results. And then you stop to think and you realize, yeah, we live in a visual world and there's no changing that. We live in a world where people are scrolling up and down, swiping left or right, and people are used to connecting any type of just auditory response to a visual response at the same time. So you need to be able to make sure that everyone's on the same page, to where if you're telling a story about a particular person, then humanize them in the PowerPoint. Show a picture of that person. That way everyone can visualize the same exact thing and everyone is on the same exact page. And you can also just create outlines for your PowerPoint. Not only will this outline help you stick to your outline, but you can also show and conceptualize to the listener, okay, this is what I'm gonna talk about, this is what I'm gonna hit on during the course of this argument, instead of just walking up there and just making this speech. Because if you start making a speech, then it's like, okay, where's this going? Where is this connecting to? How long is this gonna go for? And then at some point they think it's gonna last forever. They think it's gonna be like their college class or high school class or law school class where it's just like, wah, 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 wah. And they're not gonna really pay attention at some point in time, unfortunately. They may look like they're paying attention because I think overall as a society, we've mastered the art of like, oh yeah, I'm interested, but not paying attention whatsoever. Now, my recommendation then is to use a very simple PowerPoint that changes the pace, that changes the tone, that changes what they're focusing on from you to the PowerPoint back to you. But you can also use the PowerPoint as a way to kind of stick to your outline if you need to stick to it. If you have a picture that's representative of argument B or argument C, like we were talking about earlier, that'll help you kind of keep your reference point whenever you maybe get off topic, and then you can come right back to argument B or C whenever that picture comes up. I know that you may be opposed to, hopping on the computer, creating these PowerPoint slides, but I can tell you they are a potential game changer if you use them correctly. And if you get really good at them, then you can adapt during the course of the hearing, during the course of the trial, and you can implement arguments as they come up, and then you're gonna look like an absolute master of PowerPoint, and you're gonna look extra prepared if opposing counsel makes an argument and then you make a slide based on that argument to respond. And it really can take your argument to the next level. All right, moving on to tip number 3. Tip number 3 gets down to the fundamentals of making an argument, and the recommendation here is to control the pace of your argument. Yes, on one hand, you need to maybe talk faster, talk slower, have a pause, or talk a little bit louder, talk a little bit quieter. Yeah, you need to do all that. But this particular tip is a little bit different, because if you're going to be using PowerPoint, if you're going to be using exhibits, or if you have exhibits that are potentially going to be used or requested by the judge, you need to have a great grasp on where those exhibits are, or a great grasp on how to use the electronics, because that can absolutely deflate an argument. What you don't want to do is have this amazing argument that you practice, that you rehearse, and that you've outlined, and the judge stop you as you're building up the momentum and you're about to just hit the judge with this climax argument, this climax point. You've built up this argument and the judge says, actually, can you go ahead and find the exhibit that you were talking about maybe 2 minutes ago involving X, Y, and Z? And then at that point in time, you're, okay, 1 second, judge, and you open up the huge binder and you're having to thumb through everything and it's like, And while you're doing that, keep in mind, the courtroom is gonna sound like this. There's always somebody coughing that you didn't know was in the back. But it's just awkward, is my point. And so it is a horrible way to ruin your argument that you've been practicing for so long. So don't overlook the fact that you need to have just an amazing system when it comes to your exhibits. You need to basically memorize exactly where all these exhibits are. And whenever you're rehearsing, whenever you're practicing with your outline, in your mind, as you're rehearsing, be sure to know, okay, if anybody talks about this particular fact, this particular argument, this particular case, I know where that exhibit is. That's in section C of this binder. That's on tab, B, whatever. At the same time, if you're making an argument and you're using PowerPoint or any electronics, make sure you know how to use that, because what you don't want to do is during opening or during the hearing or the argument, start building up and say, okay, now I'm gonna show you exactly what happened. And then it's like, click, click, and there's nothing there. And that's just gonna absolutely deflate your argument. You may lose credibility, which would be horrible. So just be sure to have a great idea of, one, how to use the electronics, and then just be sure to master your exhibits, because worst case scenario, if the electronics just don't work that day, which is a possibility, make sure you have your exhibits in paper form. I'm sorry for the trees, and you can just shell them out whenever you need to. And overall, you control the pace and let the other side have those lulls during the trial. And that way, the other side is associated with the boring arguments, and the jury and the judge knows that as soon as you get up to make the argument, okay, it's game time. They need to pay attention because this is going to be interesting. All right, speaking of interesting, this next tip, also pretty interesting. This actually might be my favorite, so let's go ahead and check it out. Whew, I think I just did that entire take in one breath. I got way too excited and tried to just go ahead and power through it, but I think there's a chance I broke some type of world record. I'm gonna have to check the tape and see how long I went without breathing. Man, I need to slow it down a little bit, but at the same time, I understand that your time is valuable, so I try and get through it as fast as possible. The things I do. Tip number 4 is my favorite tip, because things get a little confrontational whenever you use it. Things get a little heated. That means things get a little bit more fun. Now, here's the tip. You need to ask a question at some point during the trial or the hearing that you know the other party or the other party's counsel cannot answer. Or if they do answer it, it's gonna be a garbage answer. Here's how this can be so beneficial to your case. If you ever determine that the other side has a huge hole in their case, there's a huge weakness, then it's your job to expose that weakness. And the best way to expose that weakness is to ask a question to the jury, to the judge, and say, here's a question that needs to be answered by the other side, but they can't answer it. We'll go through this entire hearing, we'll go through this entire trial, and you won't hear either an answer or a quality answer that is gonna be satisfactory to you. Now, keep in mind, whenever you're making an argument in the courtroom, you can't actually ask or make your argument directly to the other side. You always have to make it to the judge or to the jury. But at the same time, if you're feeling extra bold, you can do that by, saying, Your Honor, here's one question, and then look at the other side, but you're kind of, directly making this argument to the judge, but your eyes just happen to be to the other party, to the other side. And then that really, man, that makes things a lot more tense and makes things just really stand out. And it makes the judge and or the jury think, that's a fair question. Okay, let's see if they can answer it. And if the other side doesn't have an answer, doesn't have a good answer, then what that ends up doing is it takes away the other side's ability to distract from that weakness. If you just hone in on that weakness, if you pose that one question, say there's just one question that needs to be answered, but they can't do it, then that's the one question that's going to be going through the judge's mind or through the jury's mind. If it's a hearing, the judge may just take it upon him or herself to ask that one question and see if the other side can answer that question. But if you do your job, if you do your due diligence and you know they can't, then you're going to be set. And if you actually can incorporate tip number 2 when it comes to the PowerPoint, heck, I'd end on that note and I'd end on that slide and I wouldn't take my PowerPoint down until somebody was like, oh, hey, by the way, you left your PowerPoint up. And then I would play dumb like, oh, wasn't paying attention, don't know how to work these electronics. But I'd keep that question up there for as long as possible. So if the other side didn't take it down and they're going through their argument, the jury or the judge is thinking that one question the whole time, and the judge may look at that PowerPoint and say, counsel, can you answer that question that's up there right now? And that will put them in the hot seat, and that will make the other side have to try and explain something they're not comfortable with doing. This final tip is all about flipping, and no, I'm not talking about doing your best Chip and Joanna Gaines impersonation. Instead, I'm talking about taking the arguments, the themes, and the examples from the other side and incorporating those into your arguments and using their theme as your theme and using their examples to your benefit. Because if you can flip the use that the other side is using them for, then that will show the strengths of your client's case, and that will show the strengths of your advocacy skills, and it'll take you basically from a good lawyer to being a great upper echelon type of lawyer. This is a very skilled tactic, and it can be very, very powerful. It's one of those stop hitting yourself type of situations where if you can flip a theme, then that means every time the other side uses that theme, it's just not going to be beneficial to them. But let's make this a little bit more concrete with an example. So here's a quick example. Let's say the other side decides to have a theme involving choices, and their whole point is your client made the wrong choice, and that's why we're all here at this trial. Well, at this point in time, you are at a crossroads. You can either continue using the theme that you originally planned on using, or you can use their theme against them. It's one of those, again, stop hitting yourself type of situations. And let's say it's choices, and during your cross-examination, the opposing party's up there, you can cross-examine that opposing party and just repeatedly say, but you made this choice, you did this thing, you chose to do this, and just hit them over the head with their own theme. And then during closing argument, this can all build into one really like climax of a statement, which is, I agree, this case is about choices. The other side's right to that extent, but we're not talking about the choices that my client made. We're talking about the wrong choices that their own client made. And at that point in time, it all kind of comes together, and whoever is listening, whether it's the judge or the jury, they start thinking, yeah, like they're right about that. I mean, they're kind of using their weapon against them, but there's definitely some holes there. There's some weaknesses there. And overall, you just make a more compelling argument. Okay, so if you have any questions about this, please let me know in the comments below if you found this helpful. Also, leave those in the comments as well. I'd be happy to see, okay, what was more beneficial than the others. Maybe I can expand on some of these tips a little bit more in future videos. Also, don't forget to give this video a thumbs up, hit that subscribe button, and I'll see y'all in the next video.